case, the court seemed to recognize explicitly birthright citizenship. The administration points out that there's certain language in the case, and it was true, as for Wong Kim Ark, that he was born to resident aliens. And so the Trump administration says, listen, when it comes to legal permanent residents, they're covered. Their children are citizens. That was the case with Wong Kim Ark. But when it comes to temporary visitors, they're not, their children should not be citizens. So they try and square that case, but I will say there is very broad language in Wong Kim Ark where the Supreme Court seems to recognize birthright citizenship explicitly.
So what do you say to folks who aren't steeped in this, like you and your colleagues at SCOTUS blog are, when they say, well, then the Supreme Court's already decided this. Why are we here today?
Well, so two things. One thing is that one could argue that, you know, they did carve out this potential language in Wong Kim Ark that it applied to residents, you know, as they said, resident aliens. And so therefore that can be distinguished. In the law, we say, oh, a case can be distinguished, so it doesn't count against you. But there's also, you know, an outright argument that Wong Kim Ark, if it did say that, it should be overturned. And Supreme Courts overturn their own precedent. They don't do it all the time, but they think if the precedent profoundly conflicts with a constitutional amendment, then they overturn it. And this court has done that in some very important cases, and they may well do that here.
Here's where we are just after 10 a.m. Eastern on Capitol Hill. We're waiting for the Supreme Court arguments to begin. We're waiting for that feed to come up from the Supreme Court. The live oral arguments will, of course, go there immediately when they do pop up. We're unclear if it's going to pop up in the next 1 minute, 10 minutes. We're not sure if this case is being delayed because of the unprecedented nature of President Trump going to the court for the argument. We will stay here for about another 5 minutes or so and take your calls to see if that feed comes up. If it doesn't come up, we'll take you to the plaza out front of the Supreme Court for live sights and sounds of the scene out there. This is what it looks like, and that's where we'll go if the case doesn't come up. Until then, your phone calls. This is Brenda in South Carolina. Good morning.
Thanks for taking my call. And my husband, and I agreed with him, used to say that those of us born here are accidental Americans. And the people that come here who work, who go to school, who apply for citizenry and study for the test are more patriotic than a lot of us who are born here. And the other thing is, if this is a case that goes back to the Civil War era, isn't it really a disenfranchisement of the Black Americans? And, you know, he could actually take citizenry from anybody. I mean, he could take it from me. He could take away my Social Security because I'm not a citizen. He could take Medicare away because I'm not a citizen. I mean, there are so many replications about this. And
Brenda, let me take that argument with Zach Shemtab, the slippery slope argument, Zach Shemtab.
Yeah, this is a serious argument that's been proposed. If the president can put an executive order forward reinterpreting the 14th Amendment in the views of those against him, then could he continue to reinterpret until he takes away, you know, citizenship for those he thinks don't deserve it across the board because perhaps they're politically disloyal as he sees it, etc. Again, I think there would be a lot of serious other constitutional due process concerns there, but the slippery slope and the idea that this is granting the president an incredible amount of power to at will take citizenship away from people, which the Supreme Court has seen as so profound and fundamental, is, you know, something that needs to be taken seriously, and I think is taken seriously.
The case has yet to start. It could be delayed. We'll hear from Clyde, Queens, New York, independent while we wait. Clyde, go ahead.
Okay, good morning. I have to congratulate you on your congeniality with your answers to most of the callers. And one or two callers sparked something with me. I would like to give three rhetorical questions, and if you will, you can answer them or not. One, I take it that a lot of white callers and maybe one black, just a handful of black callers that I normally hear call in, always talk about how immigrants are taking, when they come over, they're going to take something away from them. And nobody ever asks them, what have they ever taken personally away from them? That's number one. Number two, one particular caller today, he said something about somebody breaking into your home, in their home, and so forth and so on. So my question would have been, how does the actual burglar get mad at the squatter who actually broke into the first homeowner's home?
Clyde, we'll have to end it there. The Supreme Court arguments have started. Zach Shumtop, thank you so much for your time. SCOTUSblog.com is where you can go to see their wrap-up. We take you now to the United States Supreme Court.
To anybody else. And in 1884, this court recognized that subject to the jurisdiction means owing direct and immediate allegiance. The clause thus does not extend citizenship to the children of temporary visa holders or illegal aliens. Unlike the newly freed slaves, those visitors lack direct and immediate allegiance to the United States. For aliens, lawful domicile is the status that creates the requisite allegiance, and the text of the clause presupposes domicile. For decades following the clause's adoption, commentators recognized that the children of temporary visitors are not citizens, and illegal aliens lack the legal capacity to establish domicile here. Unrestricted birthright citizenship contradicts the practice of the overwhelming majority of modern nations. It demeans the priceless and profound gift of American citizenship. It operates as a powerful pull factor for illegal immigration and rewards illegal aliens who not only violate the immigration laws, but also jump in front of those who follow the rules. It has spawned a sprawling industry of birth tourism as uncounted thousands of foreigners from potentially hostile nations have flocked to give birth in the United States in recent decades, creating a whole generation of American citizens abroad with no meaningful ties to the United States. I welcome the court's questions.
General Sauer, before we get into the broader national issues, would you start with Dred Scott? Dred Scott was a case about state citizenship. It was a diversity case. And of course, we know what Chief Justice Taney did with that. How does the Citizenship Clause respond specifically to Dred Scott and answers or changes or corrects its answer as to citizenship? The other point is the Citizenship Clause refers not just to national citizenship, but also to state citizenship. Are we to have two different definitions for those? It's one word, citizens of the United States and citizens of the state wherein they reside. So as you begin, I'd like you to go back at the beginning and be more specific about the answer, and I want you to explain whether or not those two definitions are the same or related, and what state citizenship is based on.
Thank you, Justice Thomas. I'll maybe start by addressing Dred Scott. As you alluded to the fact, Dred Scott, imposed one of the worst injustices in the history of this court, and it led to the outbreak of the Civil War. It's very clear, and this court in all of its early cases interpreting the 14th Amendment said the one pervading purpose, the main object of the Citizenship Clause is to overrule Dred Scott and establish the citizenship of the freed slaves. And if you look at the debates in the congressional record and discussion surrounding the adoption of the Citizenship Clause, what you see is a very clear understanding that the newly freed slaves and their children have a relationship of domicile. They do not have a relationship to any foreign power. For example, there's a comment where he says, look, people have been here for 5 generations and clearly have no relationships to any foreign African potentate, or have a relationship of allegiance to the United States. And that reinforces our point that allegiance is what the word jurisdiction means. It doesn't mean regulatory jurisdiction or or sort of being merely subject to the laws. They're talking and they're thinking about it in those debates about allegiance. Now, as to your second question, if you look at the text of the clause, we believe it says, born in the United States, born or naturalized in the United States and subject to the jurisdiction thereof, are citizens of the United States and the states of which they reside. So there's a constitutional guarantee that applies to both federal or national and state citizenship. And the key point we make there is that word reside, if you look at, for example, section 1473 of Justice Story's commentaries, was understood to mean domicile. So when they say subject to the jurisdiction, and then they go on to say you're a citizen of the United States and the state in which they reside, the very text of the clause itself presupposes that the citizen is domiciled in the United States. If they're present in a state at all, they reside there. Reside means domicile in the Constitution, and we think that strongly supports our interpretation. It's textual evidence of our domicile-based theory of jurisdiction.
Well, starting with that theory, you obviously put a lot of weight on subject to the jurisdiction thereof. But the examples you give to support that strike me as very quirky. Children of ambassadors, children of enemies during a hostile invasion, children on warships. And then you expand it to a whole class of illegal aliens are here in the country. I'm not quite sure how you can get to that big group from such tiny and sort of idiosyncratic examples.
There are those sort of narrow exceptions for ambassador of foreign public ships. Tribal lineage is an enormous one that they were very focused on in the debates as well. But what I do is I invite the court to look at the intervening step, which is the enactment of the Civil Rights Act of 1866. And there they didn't say subject to the jurisdiction thereof. There it says not subject to any foreign power. Now, if you go back to Blackstone and Calvin's case, they say it does not matter if you are subject to any foreign power. If you are born in the king's domains, you have this indefeasible duty of allegiance to the king at any time. So there's a clear repudiation in the Civil Rights Act. The Civil Rights Act is this breakwater which makes it very, very clear that they are not thinking about allegiance in the terms of like the British common law. They've adopted the Republican conception of allegiance. So it's from not subject to any foreign power, and then the debates just a couple months later make it very clear that they're recodifying the same conception. They were dissatisfied with the potential ambiguity in the phrase Indians not taxed, and they adopted subject to the jurisdiction thereof. And one of the strongest statements of this is Senator Trumbull's statement that I quoted at the beginning, where he says, he's asked, what does that mean, subject to the jurisdiction thereof? And he says, it means not owing allegiance to anybody else. And that is what it means.
Why should we be thinking about, even though as a policy matter I get the point, thinking about, gee, European countries don't have this, or most other countries, many other countries in the world don't have this? Doesn't that, I guess I'm not seeing the relevance as a legal, constitutional, interpretive matter necessarily, although I understand it's a very good point as a policy matter. Yeah,
I largely agree with that, and you can view it as being raised preemptively, defensively. I'm going first, but obviously the other side in their amici say, make it a prediction, end of the world type predictions, and our point is, it's a very small minority because almost every country, and certainly all European countries, have a different rule, and the world hasn't ended there.
The other side, last one, the other side relies heavily, of course, on Wong Kim Ark, and you disagree with their interpretation. Oftentimes, when you are dealing with a constitutional precedent like this, you might argue, we disagree with that interpretation, but if you adopt their interpretation or agree with their interpretation of that precedent, you should overrule it. And you haven't made that argument here, and I'm just giving you an opportunity to explain why you haven't.
Because we think it's totally unambiguous in Wong Kim Ark that the holding relates to domiciled aliens. And so we strongly agree with the holding. We think domicile was the touchstone, and we think that's not a coincidence for the reason I maybe speculate a little bit when I was talking to Justice Gorsuch about how the dissent raises this, and then the majority's like, we're putting domicile in there, so we know that the absurd conclusion that they say would come from this isn't there. But also domicile as kind of the sort of relationship that creates this relationship of allegiance that makes you part of a political community if you're an alien from another country. That's deeply rooted in their understanding when they're doing it. They talk about domicile in Yikwo against Hopkins in the 1892 and 1893 cases, and there's this deeply rooted understanding, again, that goes all the way back to the early 19th century. So we think that's a really important conception. So I mean, we disagree with some of the dicta in Wong Kim Ark that we discuss, and we think there's dicta that goes our way that the other side overlooks. And we're not asking the court to overrule dicta. We just say don't follow erroneous dicta and don't apply it to this brand new situation that was not decided in Wong Kim Ark.
Thank you.
Justice Barrett?
So, General Sauer, I want to zoom out a little bit and think about jus soli and jus sanguinis. So as I understand it, at the time of the 14th Amendment, those were the two dominant approaches. Jus soli, the English common law, roughly following the soil. Jus sanguinis, roughly citizenship following the parents. Now, jus soli was very generous on the soil, the English common law, and so it extended citizenship to those born there who may not have been born of parent citizens. But jus sanguinis, if parents who were citizens and had a child abroad, then that child's citizenship followed the parents. So one thing that's puzzling me about your argument when I think about the ratification of the 14th Amendment, in many ways it would have made sense for them, and you acknowledge the jus sanguinis in citing Vattel. It would have made sense in some ways for them to say, okay, we're going to follow, if they wanted to accomplish what you're saying they wanted to accomplish. You could say, well, we're going to follow jus sanguinis because we're going to make it all right on parentage. But instead, the 14th Amendment, we're talking about subject to the jurisdiction thereof, but it also says born in the United States. So you have the jus soli kind of point there, but you're saying it narrowed that point by tying it to the citizenship of the parents, at least as to soil. But I take it you're not arguing that United States citizens who have children born abroad would qualify for birthright citizenship. So it's kind of a narrower view of both the traditional jus soli rule and a narrower view of the jus sanguinis rule. So why would they have done that? And if they were going to invent an entirely new kind of citizenship, like an American brand, why wouldn't we have seen more discussion of that in the debates?
I think you do. And I would say, I think the right way to conceptualize it, it is a modified jus soli. Because even the British sources don't just say you're born here, you're a citizen. They say you're born here and you have to be under the protection of the sovereign. You have to have a relationship of allegiance. Allegiance is the word in Calvin's case.
But they don't focus on the parents. It's the child. And your approach focuses on the parents' allegiance.
Yeah, I'm not sure that that's true of the 19th century sources.
It seems a little ambiguous, and I'm going to ask your friend on the other side of that question.
Let me point out then that there are two criteria. One is birth on the soil, and the other is allegiance or allegiance. What we have is birth on the soil remains the same, right? And so they are, and that's why so much of Wong Kim Ark is actually we agree with, because they are adopting a modified British rule. They are not going the French rule, that Vattel talks about, where it's like who's the citizen. That had to be done by statute, as you pointed out, which it was in 1401. But what they've got is they say birth in the United States and subject to the jurisdiction thereof. That is talked about as allegiance, allegiance, allegiance in the congressional debates, but they were clearly not incorporating the British feudal monarchical conception of allegiance where it's indefeasible. Going back to the early 1700s, our nation had repudiated the notion that citizenship is indefeasible. The expatriation statutes from the late 1700s reflect that. And again, you look at the 1868 congressional report that we cite there, this is the same group of congressmen, Republican congressmen, and they say things like the U.S. Constitution itself is proof that Blackstone's theory of allegiance was not accepted. So they accept birth on U.S. soil, but then they take the concept of allegiance and give it its Republican, democratic, American understanding. And that's very, very, I think that makes a ton of sense.
Okay, and let's talk about its applications. So, there are some, I can imagine it being messy in some applications. So what would you do with what the common law called foundlings? The thing about this is then you have to adjudicate, if you're looking at parents, and if you're looking at parents' domicile, then you have to adjudicate both residence and intent to stay. What if you don't know who the parents are?
I think there are marginal cases. That one, I think, has the benefit of being addressed in 1401F, where it talks about...
Yeah, but what about the Constitution?
Under the Constitution, domicile is a constitutional standard in all kinds of other situations.
Well, and it's hard.
Diversity jurisdiction, personal jurisdiction, sorry.
Well, yeah, and personal jurisdiction, 1332, diversity jurisdiction. And the thing is, it has to be litigated because it turns on intent. And the virtue of both jus soli and jus sanguinis, whichever one you pick, it's a bright line rule. How would it work? How would you adjudicate these cases? You're not going to know at the time of birth for some people whether they have the intent to stay or not, including U.S. citizens, by the way. What if you have someone who is living in Norway with their husband and family, but is still a U.S. citizen, comes home and has her child here and goes back? how do we know whether the child is a U.S. citizen because the parent didn't have an intent to stay?
I'd say make 2 points, one practical, one legal. The practical point is under the terms of this executive order, you don't have to because the executive order turns on objectively verifiable things, which is immigration status. Are you lawfully present but temporarily present, or do you have an illegal status? So those kind of like, taking evidence, so to speak, under subjective intent wouldn't be done. And as to the constitutional point, obviously domicile is baked into a lot of constitutional and legal concepts, and there may be situations where facts are determined, but if you look at the guidance that all the agencies did after this court in Costa said the agency could go forward to issue guidance, the guidance provides, I think, very, very clear, objective, verifiable approaches to doing this. And so as a practical matter, I don't think it's presented by this executive order.
Thank you, General.
Justice Jackson?
Good morning, General. So I guess I am looking at your position in this case, and it boils down to requiring us to do at least these 2 things. One is believe that the framers were not importing the common law rule and understanding of birthright citizenship. And the second is to believe that what they were doing was departing from that common law rule in the way that you suggest. That is, they were seeking to have this turn on domicile. I think you have a number of hurdles to accomplish those 2 things. One of which, I think, is that when we look at this court's case law, and no one, I think, has mentioned Schooner's Exchange, but it appears that that was an 1812 case in which it seems as though the court had already accepted at the time of the ratification of the 14th Amendment that the allegiance that you are talking about was the English common law rule. That, in other words, allegiance meant that you are covered by the laws of the jurisdiction, that you can rely on that jurisdiction's protection. That's what allegiance meant. Now, you're saying today, no, allegiance meant something about loyalty or that kind of idea. But if the Supreme Court had, prior to the 14th Amendment, established that allegiance meant the common law definition, I think your first hurdle is to help us understand why we would believe that when the 14th Amendment was ratified, the framers weren't just incorporating what we had previously said it meant.
Page 572 of the congressional record directly addresses this. They say the concept of temporary and local allegiance from the Schooner Exchange is what is meant by, or temporary and local jurisdiction from the Schooner Exchange is what is meant by the word jurisdiction in the 14th Amendment. Senator Trumbull says, I thought about saying owing allegiance, but again, quote, there's a sort of allegiance from persons temporarily resident in the United States whom we have no right to make citizens. So he expressly and consciously rejected reliance on Schooner.
What do we do with, I mean, that's a debate, and it's a discussion, very valid, but then we have a subsequent debate between Fessenden and Wade, where the same concept comes up, and it becomes clear, at least from Senator Wade's perspective, that that's wrong. So Fessenden, and I'm not sure whether these are senators, I apologize. Fessenden says, suppose a person is born here of parents from abroad temporarily in this country. Wade responds, the senator says a person may be born here and not be a citizen. I know that is so in one instance, in the case of the children of foreign ministers who reside near the United States, et cetera, et cetera. So it appears as though in that exchange, at least Senator Wade believed that the English common law understanding of what it means to have allegiance, to be a temporary person on the soil, was what was being adopted.
Yeah, that exchange strongly supports us. If you look at it in context, Senator Wade has introduced a version that says only birth on U.S. soil and doesn't have any allegiance or jurisdictional element to it. And so Senator Fessenden stands up and says, well, that can't be right because, obviously, what about the children of temporary visitors? It has this, it's another one of these statements that has this appeal to a background understanding that we all agree that the temporary visitors, their children do not become citizens. And then Senator Wade has to kind of backtrack and say, well, what are the children of ambassadors? And in the end, Congress does not adopt Senator Wade's proposal. So we think that to the extent you can draw an inference from that, the inference strongly supports.
All right, well, let me just ask you about why we wouldn't see in the 14th Amendment anything about parental allegiance. Several of my colleagues have talked about the fact that your view of this turns on what the status of the parents are, and not the child, as would the born in the United States view of it. Can you help us understand why we wouldn't expect to see a mention of parents in the text of this amendment?
I think it was well understood that, for example, children cannot, newborns cannot form domicile, so it follows every 19th century.
That assumes domicile is in the test, and I'm asking you, how do we know that Congress did adopt the test that you say it adopted?
Yeah, when you're looking at 19th century conceptions of allegiance, the notion that the allegiance, again, we say domicile is instantiating the concept of allegiance for aliens as opposed to citizen. All of that, the 19th century understands the newborn's domicile, its allegiance follows the allegiance of the parents. And I point out that their theory relies on parental allegiance as well, because they recognize the exceptions for, hostile invading armies, for tribal Indians, for ambassadors. Again, the child's allegiance status, even on their view, turns on the status of the parent.
What do we do with Professor Mueller's amicus brief and the historical record and the fact that even at times in this country where we understood that the parents were declared enemies of the United States, I'm talking about World War II and Japanese internment, babies born in that circumstance were given birthright citizenship. So it seems as though this concept of allegiance of the parents really wasn't driving birthright citizenship, at least at this period of our history. So are you saying this is wrong, or they shouldn't have gotten birthright citizenship?
Well, if they were domiciled here, yes, they should have. If they were temporarily present, then no. But the executive practice, we can see from the 1930s.
How does the temporary presence run with your concept of allegiance? I'm not sure I understand. So can you be clear? Are you saying that only people who are domiciled here, as you define it, can form the necessary loyalty to the United States?
It's not allegiance is not a question of subjective loyalty.
Okay.
It is something you owe. It's a reciprocal relationship between the citizen, whether they want it or not, they have that allegiance. And I think it's powerfully—
On the basis of what?
Domicile. I mean, that's what it says in so many words in the Venus and the Pizarro. It says, look, if you're talking about an alien, if they're just temporarily passing through, no, they don't have allegiance. But if they've made it their permanent home, they become part of our political community, and they are analogous or akin to citizens.
All right, just quickly, because I'm mindful of the time. What do you do with Won Kim Ark's statement that birthright citizenship is applying, quote, independently of a residence with intention to continue such residence, independently of any domiciliation? I know that they use domicile, it's a fact in the case, but that's not a part of their holding. It's not what the reasoning turns on. Correct?
I believe you're quoting from page 693 of that opinion. It goes on to say, not citizen terms on that, but the duty of obedience to our laws. It doesn't take the further step at that point and say, therefore, if you have temporary and local allegiance, you're a citizen. And immediately before that, you have that page 693 summary of the court's holding, where it says domicile, domicile.
Won Kim Ark incorporates a domicile requirement.
That is the holding. It's definitely clearly expressed in the holding.
All right, one final thing, perspective. You say perspective, we're supposed to do this. Don't worry about the people who are already here and who would not qualify under your rule. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, Social Security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get
No, not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So are we bringing pregnant women in for depositions? What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity, there's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases, is directly addressed in that guidance.
After the fact.
Yes.
After their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I mean, I'm summarizing because I'm not an expert in computers, but there's a computer program that currently automatically generates a Social Security number. SSA says, look, a Social Security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a Social Security number, provided that the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Thank you, counsel. Ms. Wong?
Mr. Chief Justice, and may it please the court, ask any American what our citizenship rule is, and they'll tell you, everyone born here is a citizen alike. That rule was enshrined in the 14th Amendment to put it out of the reach of any government official to destroy. When the government tried to strip Mr. Wong Kim Ark's citizenship on largely the same grounds they raised today, this court said no. 30 years after ratification, this court held that the 14th Amendment embodies the English common law rule. Virtually everyone born on U.S. soil is subject to its jurisdiction and is a citizen. It excludes only those cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction, even when they're in the United States. A closed set of exceptions to an otherwise universal rule. My friend has now clearly said that the government is not asking you to overrule Wong Kim Ark. That is a fatal concession, because Wong Kim Ark's controlling rule of decision precludes their parental domicile requirement. The dissent understood that, and the majority tells us 6 times in the opinion that domicile is irrelevant under common law. Lynch versus Clark was already the dominant American case on citizenship, and it held that the US-born daughter of temporary visitors from Ireland who took the baby back to Ireland with them, that daughter was a US citizen. Authorities, including Lincoln's Attorney General and Kent's commentaries, embraced Lynch, and Kent specifically talked about temporary sojourners' children being US citizens. Justice Field said in 1884 that reflected the general understanding. That understanding was confirmed by Congress with its 1940 Act. The 14th Amendment's fixed, bright-line rule has contributed to the growth and thriving of our nation. It comes from text and history. It is workable, and it prevents manipulation. The executive order fails on all those counts. Swaths of American laws would be rendered senseless. Thousands of American babies will immediately lose their citizenship. And if you credit the government's theory, the citizenship of millions of Americans, past, present, and future, could be called into question. All of this tells us the government's theory is wrong. I welcome the court's questions.
There are 5 exceptions to citizenship that you do accept.
Yes, depending on how many you count, Justice Thomas, how you count them.
What is the underlying rule of law that you use to connect these 5 exceptions?
Sure. So as I just said, all of the exceptions involve situations where that US-born child is not subject to the jurisdiction of the United States because that extraterritoriality, the fiction of extraterritoriality, the interaction of another sovereign between the United States' jurisdiction and that person applies to the child as well as to the parent. Everyone else born in the United States is subject to the United States' jurisdiction. To answer Justice Barrett's question to my friend, that's what sets those exceptions apart from other US-born persons.
We've heard a lot of talk about Wong Kim Ark and you dismiss the use of the word domicile in it. It appears in the opinion 20 different times, including in the question presented and in the actual legal holding. And the government doesn't want it to be overruled because it's willing to rely on that particular fact in that case. Isn't it at least something to be concerned about, to say that since it's discussed 20 different times and has that significant role in the opinion, that you can just dismiss it as irrelevant?
Well, Mr. Chief Justice, I think we have to look at what the controlling rule of decision is in Wong Kim Ark. Justice Gray takes pains in the majority opinion to set out his analysis. He first starts with a premise that in construing the 14th Amendment Citizenship Clause, we look to the English common law. That was the rule that applied from the colonial era on, at least for the colonists and for European immigrants. He then says, look, Chief Justice Marshall tells us in the Schooner Exchange what subject to the jurisdiction means, again looking to the English common law. Under English common law, if you are born in the dominions of the sovereign, you owe natural allegiance, and those who are present in the dominions of the sovereign owe temporary allegiance for as long as they're present. The only exceptions, again, at common law were ambassadors, people born on foreign ships, and people who were born during periods of foreign occupation. He then gets to the government's favorite page, 693, where he says, look, we have had this rule in the United States as to citizenship, at least for white Americans, from before independence. The purpose of the 14th Amendment was to embrace that universal rule of birthright citizenship, to embrace and incorporate the common law exceptions with the single additional exception of the pre-existing exception for tribal Indians that we had in the United States, which is an analogous exception, and that's the closed set of exceptions. You can't make sense of the holding in the case without looking to the controlling rule of decision, which is the common law. And I think my friend agrees that under English common law, domicile was not relevant, and the children born to temporary visitors in the territory of the sovereign were always considered birthright citizens.
Well, Ms. Wong, I mean, everything you say strikes me as, yeah, that's the way I read it too, but then what are those 20 domicile words doing there? Like, you can, take some of them and say, they were just summarizing the facts of the case, but not all of them. And why did they keep on, why did they sprinkle that in the opinion?
Well, I think, again, those were the stipulated facts in the case. And it's clear we have textual evidence in the majority opinion that they were simply saying this is an a fortiori application of that controlling rule that comes from the English common law. Justice Gray writes, again, after setting out the English common law rule and the exceptions with the single additional exception for children of members of Indian tribes, that the amendment in clear words and manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. And as was pointed out earlier, the very next part of that same paragraph,
he cites to Webster talking about Thrasher's case, and he says, people who are born in this country owe allegiance independently of a residence within, foreign nationals owe allegiance independently of a residence with intention to continue such residence, independently of any domiciliation, and independently of taking any oath of allegiance, which is totally contrary to both the government's theory of dual allegiance or partial allegiance and to the theory of domiciliation.
I mean, I might agree with you if domicile had simply been sprinkled in the opinion. But in Wong Kim Ark, it's a long opinion, but it begins by saying, here's the question, and it ends by coming back to the question. And it says, here's the question, stated at the beginning of the opinion, namely, whether a child born in the United States of parents of Chinese descent who at the time of his birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business, and he states the diplomatic exemption, and he says, for the reasons above stated, this court is of the opinion that the question must be answered in the affirmative. So why put domicile in? Sometimes it's hard to figure out what is the holding of the case. Here he tells us this is the holding of the case. Why put domicile in there? Well, it's just something, it's something irrelevant that he wanted to throw in. It's like, whether a child born in the United States of parents of Chinese descent who once resided at a particular address in San Francisco, who attempted to enter the country at the port of San Francisco. Why put it in if it's irrelevant?
Well, Justice Alito, I'll give you two responses. The first is that, again, it was a stipulated fact. The second is that regardless of what the judgment in the case was, which again was an a fortiori application of the rule of decision, the rule of decision in Wong Kim Ark has binding precedential effect. Even if you think that Wong Kim Ark decided the case based on the stipulated facts, you have to follow that controlling rule of decision. And if you follow that rule, you get to the same result for people without domicile. Wong Kim Ark says 6 times in the first parts of the opinion, as well as on the page the government focuses on, that domicile is not relevant.
Well, Ms. Wong, on that, what do we do with the fact that after Wong Kim Ark, at least some authorities took the view that the non-domiciliary question wasn't decided, remained open, and even continued to press the view that domicile is required? Now, I know you've got a lot of good stuff on your side, too, but what do we do with the fact that many sound legal authorities thought it remained an open question, even if one of them wasn't John Marshall Harlan?
I liked your example from Justice Harlan's lecture here in D.C. So here's what I would say. All of the government citations in their brief generally either were rejected by Wong Kim Ark expressly, if they predated Wong Kim Ark.
If we're trying to understand how the legal community understood what happened in Wong Kim Ark,
Sure.
It seems to me it's a mess.
So
maybe you can persuade me otherwise.
I think I can, Justice Gorsuch. First, as to the post-Wong Kim Ark authorities that the government cites, each one of them is inconsistent with Wong Kim Ark's reasoning or doesn't mention it at all. Most of them have very little reasoning at all. And in contrast, what we have on our side, post-Wong Kim Ark, is numerous federal court decisions around the time of Wong Kim Ark, between ratification and Wong Kim Ark, that said that domicile is not relevant. They cited Lynch versus Clark, which again was about the daughter of temporary sojourners. We have the 6th edition of Kent, which was cited in Wong Kim Ark, and of course was then cited after Wong Kim Ark was decided by many authorities, again discussing temporary sojourners. Anyone who wanted to know what the law of citizenship was under the 14th Amendment after Wong Kim Ark would go to the 6th edition of Kent, where he says in that footnote on page 38 that the rule was Lynch versus Clark, and temporary sojourners' children are U.S. citizens. We have members of Congress speaking on the record on debates on immigration laws, where they were finally passing these immigration restrictions that Senator Cowan wanted. And they all stated either that Lynch was the rule, that Attorney General Bates had stated the rule, again citing Lynch, or Kent, and stating the rule that everyone born in the U.S. is a citizen, and saying, look, the children of Chinese immigrants, these immigrants who are unwelcome, these immigrants that Congress is now trying to bar from entering the United States, if their children born in the United States are citizens. We have in 1896, so a couple years before Wong Kim Ark, but in 1896, State Department regulation, which said the U.S.-born children of foreign nationals are U.S. citizens, accepting only the children of ambassadors. And then you have Marshall Woodworth, who is a U.S. attorney who writes in a law review article that he's talking specifically about temporary sojourners' children, and he says, I don't think that's a good rule from a policy perspective, but that's the general rule.
Ms. Lang, can I,
Yes.
Can I offer a possible explanation for why Justice Gray made a point of putting domicile in what he said was the holding of the case? And it is this. Wong Kim Ark and his parents had they come to the United States from Europe, could have been naturalized. But because they were Chinese, they could not be naturalized. And they had done everything that they could to make themselves Americans by establishing a domicile in the United States. And so that's what this was about. He couldn't get naturalized because of a racist law, but they had done everything they could to become part of the American society. At the same time, there were many, many men who were horribly exploited, brought to the United States to work on the Transcontinental Railroad, to work in mines. They were worked to death. They were treated horrifically, but they were overwhelmingly men. There wasn't an indication that they would stay here, they could stay here, they didn't have permanent homes. And the opinion is drawing a distinction between those two categories of people who would have been well understood at the time when Wong Kim Ark was decided.
No, Justice Alito, I don't think that's a plausible explanation for why domicile is mentioned in Wong Kim Ark, because again, the controlling rule of decision based on the English common law and cases from Schooner Exchange to Lynch versus Clark to State versus Manuel, which was the North Carolina decision that said, look, the rule in the United States from independence on has been the English common law rule. That explanation would be inconsistent.
But Ms. Wong,
yes.
Isn't that explanation, I take Justice Alito's point, and I think he actually makes a good one in the sense that it could be that Justice Gray emphasized domicile to help the public accept the outcome of this case. You're suggesting that the emphasis on domicile was not a part of the rule, meaning he wasn't saying you had to be like a foreigner who is doing everything they can and who can't be naturalized, but he might have emphasized those facts in this case precisely because Chinese immigrants were unwanted, precisely because he had to get this out into the public, and people were going to say, whoa, you're saying these people have to, this baby has to be a citizen? And so one could imagine that it was important from a standpoint of helping people accept this citizen rule under these circumstances to emphasize that these particular people in this case were in Justice Alito's first category.
I think that is very possible, Justice Jackson, and as evidence of that, I would point to the fact that if you look at the briefing in Wong Kim Ark, you'll see that even though the parties had stipulated in the district court that Wong Kim Ark's parents were domiciled in the United States, when the case came to the Supreme Court, the government's brief argued that it was impossible for Chinese immigrants to have domicile because they expressed the view that was common among people who opposed immigration by Chinese nationals to the United States. There was a common view that Chinese people were inherently temporary sojourners in the country. And so I do think it's possible, Justice Alito and Justice Jackson, that he was trying to dispel that notion and tell the government.
Absolutely, that at least it reads as though he's trying to calm everyone down. These particular people were domiciled, but we're following the English common law rule. And when you look at the English common law rule, domicile is not a factor.
That's right. I think, who knows why the majority opinion mentioned domicile. We know it's a stipulated fact. We know the government tried to renege on that stipulation and rely on this assumption on the part of anti-Chinese advocates at that time that Chinese people couldn't form a domicile in the United States, and he followed the English common law rule.
Ms. White, go ahead. I just wanted to ask you a question about how the exceptions fit within the general rule. You've called them exceptions, and some of the common law sources call them exceptions, so I take that point. But if we think of use solely as tied to the territory, and we look at the exceptions as territorial in a sense, then they seem kind of like natural outgrowths of that rule, and this is what I mean, and this is where I want your help with how the exceptions played out in practice. If you look at Indian reservations as,
unique places because Indians were quasi-sovereign, separate nations in the American system. If you look at occupied alien territory as territory that's outside the jurisdiction of the United States, and then if you look at the diplomatic exception, almost like diplomats and their children had little bubbles around them, like the embassy is really the territory of that country, and even when they're traveling around, they're all not subject to the jurisdiction by virtue of this territorial fiction. Are those just applications of the rule? And if they are, then what happens to alien enemies like the German spies in Ex parte Quirin, or what happens to Indians who are actually not on the reservation but may be born, say, in Baton Rouge? How does the rule apply in those situations? Does it travel with the person, or is it tied in some sense to the land?
Sure. So let me answer each part in turn. So the thing that all of the exceptions have in common, again, is this sense that the person has this fiction of extraterritoriality around them. Let's set aside the Indian tribal exception for a moment and come back to it. So the example of enemy aliens, for example, ex parte Quirin, is one that is answered by Justice Story in both Inglis and in Rice. And the touchstone under the American application of English common law was that in wartime, the touchstone is whether there's a foreign occupation of U.S. territory. So,
and that's, just to interrupt for 1 second,
sure.
to clarify, and that is territorial. Sometimes it just seemed to me that the rule varied. Sometimes it was stated as enemy alien, and sometimes it was focused on occupied territory.
Sure. So the rule, I don't think there's a separate rule for enemy aliens, and the government's briefs describe the exception as an enemy alien exception. I don't think that is the best way to think about it. Rice and English tell you that when the British forces are occupying Castine, Maine, no one is subject to U.S. jurisdiction there because Britain is governing Castine, Maine. And Justice Story explains, look, if the U.S. then retakes that territory, babies who are born to U.S. citizens by what he calls post limine become U.S. citizens. So that's the way to think about any wartime situation, enemy aliens or otherwise. As we heard earlier, Professor Muller's amicus brief tells us how we've thought about enemy aliens in wartime. Even in World War II, when the United States was detaining Japanese nationals who were deemed enemy aliens of the United States, when those enemy aliens had babies in these detention camps, everyone agreed that those babies were U.S. citizens. And Professor Muller goes on to explain that there are many cases of those U.S. citizens going on to a lifetime of government service to the United States. Everyone agrees those babies are U.S. citizens like everyone else. So again, the touchstone for enemy aliens is.
So what about Indians? What about the Indian who's off the reservation or born off of a reservation?
Sure. So to start with the basics, I'll refer to the Indian tribal exception just to use the term of art. The Indian tribal exception, Elk versus Wilkins tells us, comes from the constitutionally unique status of Indian tribes. In the Indian Commerce Clause, we know that tribes are treated as basically quasi-sovereign nations. We know that from the Marshall trilogy of cases. We know from Worcester versus Georgia, where Chief Justice Marshall said that the tribes are essentially a distinct political community.
Well, I understand all that. So just in the interest of time, just to focus you, how I understand why the Indians are treated differently for purposes of the law, but I want to know, is it tied to territory or is it tied to the status of someone as a member of a tribe? Because if you're looking at it because of the special relationship of Indians to the United States as a matter of the Constitution, et cetera, well, I mean, citizens of France are citizens of a different sovereign as well.
Sure. So Elk versus Wilkins doesn't really answer that question. The court says there are two ways to look at this. Either you look at it as the tribal member is like an ambassador, or you can look at it like there's a territoriality issue where people are born on tribal lands, and therefore they're essentially, I think he says, Justice Gray says at one point, we might as well be talking about someone who's born in Mexico.
Well, there's a lot in Elk, and some of it's not terribly helpful for you, it seems to me, because Justice Gray, again, strikes again, says that they may be subject in some degree or respect to the United States. So there's some jurisdiction. He says they're born in the geographic limits. They are in a geographical sense born in the United States. But because they are not completely subject to the jurisdiction of the United States and owe allegiance distinct from the United States, that's what takes them outside. And that language sure sounds a lot like the Solicitor General's presentation today.
To the contrary, Justice Gorsuch, I embrace that part of Elk versus Wilkins' holding. Justice Gray, of course, wrote both Wong Kim Ark.
I know, and it's a struggle.
Sure. Let me try to help you out with that. The government tries to make it seem as though what sets the exceptions apart, what defines the exceptions, is that the government has some maximum theoretical power. The government could have exercised plenary regulatory power over the tribes, and therefore that's the same situation as a foreign national in the United States. But that's actually not true, because remember, if there's always this background notion, whatever the parameters of the relationship between the United States government and tribal nations at that time of ratification, there was this constitutionally distinct status of the tribes and tribal members, setting them, excluding from apportionment, which was renewed in the 14th Amendment. And that's not true for nationals. If the government were right that the question is what's the maximum theoretical power the government has, there'd be no ambassador exception, because of course the United States could decide in some instance to go ahead and prosecute an ambassador. There would be inter-sovereign comity considerations there. That's how you define the exceptions. And as Wong Kim Ark says, Elk versus Wilkins has no bearing on the question of foreign nationals.
Ms. Wong, on the earlier answer you gave to Justice Gorsuch on the temporary sojourners cases, those were distinct cases, correct, where the parents had come to the U.S. and didn't want to give citizenship to their kids, took them out immediately, correct?
I'm sorry, Justice Sotomayor, I'm not sure which cases you're referring to.
All right, that we can look at.
Okay.
Ms. Wang, would you agree that the citizenship test in the 14th Amendment is the same as the test in the 1866 Civil Rights Act?
So the words are obviously different. What Wong Kim Ark tells us and what the debates tell us is that the framers, it was the same Congress, obviously, framing both. Congress was trying to do the same thing with both the 1866 Act and with the 14th Amendment. They wanted to capture the common law exceptions and the Indian tribal exception. They started out with the two separate phrases, not subject to any foreign power, plus excluding Indians not taxed. And as Justice Gray described it in his majority opinion in Wong Kim Ark, they decided to switch to the affirmative phrase, subject to the jurisdiction.
Yeah, well, do they mean the same thing? And wouldn't it be very odd if the citizenship test in the 14th Amendment were broader than the citizenship test in the 1866 Civil Rights Act, particularly in the light of the fact that the 1866 Civil Rights Act was reenacted after the adoption of the 14th Amendment and remained in place until 1940.
Sure. The framers were trying to do the same thing with the language in both.
Okay, so then I think we can turn to the language of the 1866 Civil Rights Act because it's more straightforward. Subject to the jurisdiction thereof is like the puzzle wrapped in an enigma, wrapped in a mystery, but not subject to any foreign power is pretty straightforward. So let me give you these examples. A boy is born here to an Iranian father who has entered the country illegally. That boy is automatically an Iranian national at birth, and he has a duty to provide military service to the Iranian government. Is he not subject to any foreign power?
Not within the meaning of the 1866 Act, Justice Alito. And that's clear from Wong Kim Ark, and it's clear from the debates. What the framers meant by the phrase not subject to any foreign power was referring to the ambassador exception. If it meant what the government contends, basically not a subject of any foreign power, that another country considers you a jus sanguinis citizen, then lawful permanent residents, all foreign nationals.
Well, ordinary public meaning of that would certainly encompass that boy, would it not?
Justice Alito, if you think that the language of the 1866 Act was ambiguous, as Wong Kim Ark says, the shift to the language of the 14th Amendment, which is the operative text, certainly clears up any ambiguity.
What I said about a boy born to an Iranian father is true of children born here to parents who are nationals of other countries. If I'm correct, it's true to a child who's born here to Russian parents. It's true to a child who's born here to Mexican parents. They're automatically citizens or nationals of those countries and have a duty of military service. It sure seems like that makes them subject to a foreign power.
But again, Justice Alito, that would have meant that the children of Irish, Italian, and other immigrants, which Wong Kim Ark refers to and the debate the framers refer to, would not have been citizens either. Because if the only test is whether that US-born child is considered a citizen by another country under their jus sanguinis laws, then no foreign nationals' children would be.
Well, in all of those cases, the parents could be naturalized, and then the children would be derivatively naturalized when the parents were naturalized. Wong Kim Ark, I'm sorry, the red light is on. Wong Kim Ark has a passage explaining how this court should treat dicta. And it quotes something that John Marshall said. It is well, this is quoting from Wong Kim Ark, it is well to bear in mind the oft-quoted words of Chief Justice Marshall, it is a maxim not to be disregarded, that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. If they go beyond the case, they may be respected, but ought not to control the judgment in a subsequent suit when the very point is presented for a decision. So does that fall within the, what's good for the goose is good for the gander rule? That's how Wong Kim Ark treats what was said in the slaughterhouse cases. Should we apply that same rule to Wong Kim Ark itself?
Wong Kim Ark tells you what to make of the slaughterhouse dicta. It was dicta. The issue of citizenship was not at play in slaughterhouse. And in contrast, the parts of the holding, the parts of the decision that I alluded to are the controlling rule of decision. Again, we look to the English common law in construing the 14th Amendment.
Thank you, counsel. Justice Thomas? Anything further, Justice Alito?
Well, just a couple more questions. So if those who framed and adopted the 14th Amendment had wanted to limit the citizenship test to just those specific groups that you concede